Okay, good morning, everybody. Nice to see you all. Welcome to a new event in our Law and Technology and Economy seminars. Today, I'm incredibly delighted to have Herb joining us from Philly. A couple words about our speaker. Herb is one of the most prolific antitrust scholars in the world, but most importantly, arguably, and I will make that point, the most influential competition law scholar there is out there. In fact, you are by far the most cited by the US Supreme Court and by other academics. You've been taking that number one position for so many years now that I think you pretty much match Rafael Nadal winning Roland Garros 14 times, something we won't ever see probably ever again. So it's very good to have you here. I must say that on a personal basis, when I studied in the US in the law school, I had the little version of your treaty on the black letter of antitrust law. And I used to know that book so well that I could tell you if you dropped any concept related to antitrust, whether tying, predatory pricing, horizontal collusion, that I could tell you the page number in which you will cover that concept in your book. So that helped me actually get a A+ in my antitrust course. So thank you very much for that. It's very good to have you here. You have a book that you published about a year ago with the MIT Press entitled Tech Monopolies. And today you're going to, in a sense, take the subject of the book and make it relevant to what's happening in the US and also in the EU when it comes to the big tech companies and potential breakup and remedies imposed on those companies. As you will see, this is very current, and in the coming days or weeks we're going to see a lot happening, and it's going to be extremely helpful to be able to go back to your lecture here today. The way we're going to do it is the way we always do it: half an hour for our speaker, then I'm going to ask you 1 or 2 questions to get us started, and then we have about 20 minutes for your questions over here. So on that, Herb, thank you so very much for joining. A big round of applause already, and look forward to your discussion.
Thank you. Appreciate that. And thank you so much for the invitation. This came as somewhat of a surprise because I was on my way to Europe for some other reasons, but I'm so glad to be able to do this. Yes, there's a lot going on in big tech in US law right now. The one event that I'm going to spend a little bit of time on towards the end of this talk is the remedies procedures involving Google search. The Google search case has proceeded in 2 parts. I think most of these cases will, but the first part accused Google of monopolizing the market for consumer search, and the district court found liability in that, then held the case over for what's amounting to a second set of litigation, including a lengthy hearing on the appropriate remedy. And that remedies trial concluded just this past Friday. And so now everything's sitting in Judge Maida's hands once again, and he has promised to have a decree on the remedy sometime in August this summer. But then in addition to that, we've got a case involving Facebook, principally its acquisitions of Instagram and WhatsApp. We've got another case involving Amazon, one involving Apple, and a second one involving Google and its sale of advertising technology. So there's quite a bit going on. What I'm going to do today is give just kind of a U.S. perspective on what the authorities are looking for, my own particular view about what I think they should be looking for. And then, like I said, we'll finish off with a bit of a discussion about remedies. Boy, that's big. Okay. I mean, really the 3 goals of...
You also have it here, by the way.
Oh, yes. Okay. That one's too small. Yeah, I can't read that one.
Same for me.
The 3 things we look for under the consumer welfare standard in the U.S., I don't think they're very much different from what the EU looks for, is the three-legged stool of consumer welfare is price, output, and innovation. Price is the one that's most familiar to laypersons and consumers. They think about things in terms of price. You often hear them complain that the price of eggs is too high. They don't usually say something like the output of eggs is too low, although that might mean exactly the same thing. But consumers think of price. Economists tend to think more of output, and so a lot of modeling and antitrust is concerned with things that threaten realistically to reduce market output. The third one, which is least often asserted, but very, very important, and particularly in the big tech cases, is impact on innovation, in which, of course, antitrust law does not make innovation policy so much as looks for restraints on innovation. And one important thing at the very bottom of this slide is that these concerns apply not only to liability rules, but also to remedies. Now, that might be a little bigger issue in the U.S. than it is in the EU, because you use fines so much more often than we do. In fact, our courts don't have the power to issue standard fines in civil actions. So we're always thrashing about to find the right remedy. Of course, you can lose everything if you win a good case, but then have a bad remedy. So we spend quite a bit of time on remedies, and I'm going to talk about remedies quite a little bit later on. Okay. The other thing about antitrust is that it never has enough enforcement money. Antitrust agencies always have to make choices to apply their limited resources where they will do the best. Although this triage problem, is really not exclusively one about scarce resources. It's also a problem with respect to error rates. That is to say, you want to make choices in places where you can do the most good and where the risk of doing something bad is the lowest, okay? And that means that, traditionally in antitrust, we focus on stagnant markets that are not showing a great deal of innovation, that have had rigid market shares for a long period of time, a propensity to collusion. Nothing much is happening in these markets. They're usually highly concentrated. And those are good places for antitrust to look, because it can find violations more easily, and it can also apply successful remedies more easily. In fact, if an industry is performing very poorly, then the likelihood that a well-designed remedy will make it perform better is pretty high. One of the problems is that none of these qualities applies very well to digital tech, to online markets, large tech platforms, and so on. The rate of innovation, the rate of growth in digital markets is significantly higher. Now, these are U.S. numbers, but digital tech last year had a growth rate of about 3 times the amount of the growth rate of the offline economy. That's actually a little bit lower than it has been. It was at one point as much as 4 times higher. So it might be moderating a little bit. But nevertheless, the fact is that the digital economy is growing significantly faster than the offline economy. The digital economy overall is characterized by high rates of innovation. If you think of patents as a good measure of innovation, I happen to think there's a lot of problems with that, but it's one of the few things where you can actually count something. But Apple, Alphabet are among the highest patent recipients. I'm talking about initial patents, not acquired patents, acquired from other people, but acquired by patent application and creation. And all all of the big tech companies are in the top 10% in terms of patent acquisitions, where they share that uh, they share that position mainly with telecommunications companies, chip manufacturers, and pharmaceutical companies. So these are highly innovative companies. There's not all that much evidence that firms in the internet economy, including big tech, have a collusion problem. That's not to say that there isn't any collusion, but you don't see a lot of price fixing, a lot of morbidity like you might see in a traditional uh, industry. In fact, big tech seems to be behaving very competitively, even when there's a relatively small number of players. A good example is the recent experience in the last couple of years with AI, where the firms appear to be competing very aggressively, looking for ways to outdo one another, to differentiate their offerings, which always makes collusion less easy to pull off. So, overall, the competitive picture of big tech is pretty favorable. And that suggests to me that this whole idea, particularly in the Biden administration, for the previous Biden administration, of making big tech a major focus of antitrust litigation, I believe that's fundamentally wrongheaded. I certainly don't believe big tech should have a free pass. No, they should be investigated for antitrust violations when there's probable cause to find them. I happen to think that the Google search, the Google ad tech, Facebook cases were all well brought. But I don't think there's any good reason to single out big tech for particular hostility in the antitrust arena. And that is particularly true when you're talking about remedies. Because when you're dealing with firms, in contrast to those other firms, when you're dealing with firms that are highly innovative, where things are moving quickly, where market shares are changing all the time, courts are really out of their element. And it's much easier to make a market worse through a badly structured remedy than it is to make it better. But bottom line is an antitrust remedy succeeds by looking at those same three things. It succeeds when it delivers lower prices, at least in those markets where price is relevant. That's not all of them. Higher market output and removal of any restraints on innovation. Now, in contrast to that, the labor share, once again, I'm focusing on US numbers, the labor share of production has been declining for the last 3 or so decades. Wages have been falling behind. And so that tells me that labor is an area of antitrust law that needs more attention, more policing of no poach agreements, of non-competition agreements, and most fundamentally, I believe, more attention being paid to the thing that best serves labor markets, which is keeping product output high. That's one place where the Biden administration really fell short. They were very aggressive about going after no poach agreements, tried very hard to get a blanket prohibition against employee non-compete agreements. However, they did not pay adequate attention to the fact that a healthy product market is conducive to a healthy labor market. When product market demand goes up, because labor market is driven by product demand. So when product demand goes up by 25%, labor is substantially a variable cost. Then labor goes up in proportion. So that's the kind of thing we should be looking for in labor markets. Market power has traditionally been regarded as the target of antitrust enforcement, and all three of those legs, price, output, and innovation, can relate to assertions of market power. I think it's clear today, and we are debating this quite a bit today among economists, so that is that market power measured as it classically is by some relationship between prices and marginal cost, what you might call Lerner index metrics for market power. Market power goes up when either prices go up or when costs go down. And I think one little bit of myopia in the antitrust treatment of market power is that by saying things very generally, like the merger guidelines do, 2010 is the most expansive. The unifying theme of these guidelines is that mergers should not be permitted that facilitate the exercise of market power. Well, the thing is, a merger that anti-competitively raises prices does facilitate the exercise of market power. However, a merger that significantly reduces the post-merger firm's costs can do exactly the same thing. That is, it increases price cost margins because costs are falling rather than prices are rising. That creates a phenomenon in today's market that's not all that dissimilar from what was going on with the trusts, the big trusts 100 years ago, back in the very late 19th century and early 20th century, when America first encountered its trust problem. That was through firms like Standard Oil, DuPont, a little bit later Ford Motor Company, Carnegie Steel, which became U.S. Steel, American Can Company. What was characteristic of all of those firms is that they migrated from, very small firms that tended to make things by hand to much larger firms that tended to do things at much larger scale. And one of the attributes of the early trust movement was that the firms became much bigger, but prices became lower. In fact, one of the reasons they did so much damage to smaller businesses is because customers liked their lower prices and substituted away. Well, today we've got, more detailed data on what's been going on. Now, this is from a very important paper about a year ago by Christopher Conlon and Nathan Miller, a couple of other co-authors, that looked over about a 15-year period and finds basically this, looking at the domestic economy. Marginal costs have been falling. Why? Well, digitization is a substantial factor in that, but economies of scale in other areas as well. Prices, on the other hand, have remained more or less level. They haven't fallen at the same rate. And as a result of that, price cost margins have increased. And thus, if you look up at the top graph on markups, you'll see that markups have been going up. Okay, so you look at that data, and if you look particularly at the top graph, you say, well, we've had a problem with rises in market power. That's true. Market power assessed by any variation of the Lerner index would appear to be going up over the last couple of decades. On the other hand, because marginal costs have been going down, prices have not been going down as well. Now, how much, this is all macro data, how much of it is relevant for antitrust? Well, on a case-by-case basis, very little of it is relevant, except for one very important factor, which is that it should not be the goal of antitrust policy to pursue lower costs, right? That was the brown shoe fallacy, the thing that said that merger is bad because it enabled this is a 1962 case, because it enabled post-merger brown shoe either to sell shoes at a lower price or to produce better quality shoes at the same price. And as a result, the merger should be condemned. Well, today we think of that as absolutely contrary to the goals of the antitrust laws. And I rail at my own students about this. I say, you really think the point of merger policy is to prevent people from making better shoes? No, of course it's not. We're concerned about one blade of the market power scissors, and that is higher prices, not uh, not lower costs. Uh, the Biden administration officials railed at consumer welfare. They advocated for policies that would be more favorable towards small businesses that were less explicitly concerned about prices. Indeed, Mr. Cantor, who was head of the Antitrust Division during the Biden administration, even acknowledged as he came in that one of the things that would very likely happen is that they would end up condemning mergers that resulted in lower prices. I think it's fair to say that the political winds were such that that effort could never have succeeded. And the fact is, what the agencies learned very quickly is if you want to win cases, nothing succeeds quite like consumer welfare. So if you look at the boldface on these are all from recent complaints. U.S. versus Apple filed roughly a year ago. Uh, uh, Summarizes its accusations in terms of failures with respect to lower prices, higher output, improved innovation, or a better user experience. I mean, you can rail at consumer welfare all you want, but that is about as orthodox a statement of the consumer welfare principle as you can find anywhere. The Amazon complaint also filed in 2024. Once again, uh, talks about price, product selection, quality, and innovation as the reasons for going after Amazon. And then the Facebook case at the end, that was actually brought in the very last tail end of the first Trump administration, also talks about, makes claims that the benefits of competition include lower advertising prices, increased choice, quality, and innovation. So, price, output, and innovation, they are there. Any effort to dislodge them has apparently failed, at least for the time being, and I don't expect it to change very much about that. Indeed, those metrics of performance have dominated in U.S. thinking for a century or so. The Harvard School, which was famous from the 1930s through the 60s or so, was well known for what was called the structure, conduct, performance paradigm, which saw the goals of competition policy in basically in terms of structure. I mean, the one principal contribution of the Harvard School was the idea that if you understood the structure of an industry, then you really didn't have to be quite as fussy about evaluating bad conduct because conduct is always so ambiguous. And so what we think of as, the big Harvard School antitrust cases like Alcoa, the aluminum case in 1945, the DuPont cellophane case in 1957. These are all cases, United Shoe Machinery in 1950s. These are all cases that, if you look at the opinions, a huge amount of them pertains to questions about what the relevant market is, what the market shares is, and then the conduct becomes relatively unimportant, certainly in contrast to the progressive era, in which antitrust cases read more like tort cases. There were big litanies of all of the bad conduct that defendants did. The Chicago School was anti-structural. It was focused much more on a more rigorous application of price theory rather than structural concerns. However, it agreed with the Harvard School in terms of the goals. The goals should be high output, high market output, low prices, and unrestrained innovation. And the so-called post-Chicago School, which is much more diverse, a little bit harder to pin down, pretty much agrees as well that those are the three things that are important. The Neo-Brandeis School disagreed with that for the time it was in force. Made an attempt to reinvigorate the brown shoe case, where actually delivering lower prices and better quality was the harm caused by a merger rather than the other way around. It appears that, to an extent at least, that is coming to an end, although the Trump administration continues with a certain amount of fervor against big tech. Let's see, I'm going to run out of time soon, so I want to pick this up a little bit. Okay, so one of the big issues right now has to do with remedies, where there seems to be a consensus in the U.S. that the goals of the remedies should be evaluated in terms of impact on output, impact on price, and impact on innovation. And then the question is, how do you get there from a certain type of violation? First of all, our track record on structural remedies and monopolization cases has not been good. Standard Oil led to immediate price increases after a divestiture. The Grinnell case broke up non-competing municipal monopolies, so it really didn't do anything to break up monopoly. United Shoe Machinery breakup immediately drove that company into bankruptcy. The one relative success story was the AT&T consent decree, although there, I think it's fair to say that the real boost to competition did not come from the regional breakups of the telephone companies, but rather from the global interconnection obligations that turned that into a much more competitively structured network. Today, our history of breakups basically suggests the following, looking principally at Microsoft. Microsoft is the case that all of the current antitrust cases are kind of litigating under its shadow. We've had our best successes when remedies have removed exclusivity provisions in license agreements or contracts. So, for example, the Microsoft case involved a lot of exclusivity provisions that were designed to shift traffic away from Netscape, the target in that case, to Internet Explorer, Microsoft's own browser, and had a certain amount of success. Where we've really had poor success is in breaking up assets that were internally developed. That is, taking firms whose growth has been substantially internal. There's always a lot of collateral acquisitions going on along the way, but when you break up a firm whose growth has been largely internal, and that's certainly true of Google search, you're stepping into pretty hazardous territory. A little bit better is our record with respect to splitting off acquired assets. That's why I think the Facebook case has a much better chance of success, because the real issue in that case is whether Facebook needs to spin off two assets that it acquired, namely Instagram and WhatsApp. And then finally, this is where all the difficulty is going on right now in the Google search remedies litigation, has to do with some kind of forced sharing, which ranges from interoperability, that's dynamic interoperability, where multiple firms get access to the same information more or less in real time, data portability, which is a little bit different. That's talking about the right to carry data from one firm to another. And then the all-important question at the bottom, whether Google search really is a market that can be broken up into multiple pieces, because if it's a natural monopoly, that is, if costs go down continuously as size goes up, then there may not be any equilibrium in which you can have multiple search engines provided. Okay, right now the litigation in Google search is focusing entirely on causation and how this relates to liability. and what happened in Microsoft is the court said, well, okay, Microsoft's done a lot of bad things. However, government, you have not established that Microsoft's market power was caused by these particular things. And the Google search conclusion was exactly the same. Court found liability against Google. The main practice being challenged was very, very big payments that Google was making to other firms. Apple was the biggest recipient, but hardly the only one, in exchange for making Google search the default search engine on their devices. So this big payment in excess of $20 billion a year to Apple to make Google search the default search engine. Those, I think, are going to be struck down or modified significantly, although that issue is not without problems. The thing that the court really focused heavily on in the Google search liability trial was those big exclusivity payments. However, the court also said the record is not clear on the question whether Google search's dominant position, and it is a heroically dominant position, in excess of 90% market share, 94% actually at the time the case was filed. So even Microsoft's Bing, Microsoft's a bigger company than Alphabet, but it had something like a 4% share of the market for search. Yahoo, DuckDuckGo is less than 1%. So Google absolutely dominated the search market, and Judge Maida said we can't determine from the record if Google search's dominance was a consequence of these bought and paid for search engine defaults, or whether it was Google search's own product superiority. Now, what Microsoft said, because we don't know yet what the court's going to say on the remedy. What Microsoft said is that if the goal of the remedy is simply an injunction against exclusive contracts, for example, then you can meet that requirement simply by showing that this is the type of conduct that is reasonably capable of creating or maintaining monopoly power. You don't have to show that particular conduct was the exclusive or dominant cause. Flipping to the bottom of this slide, the Microsoft case said, however, if you're going after divestiture, which is a much more aggressive and much riskier remedy, then you have to make a much clearer showing that the dominant position was a result of the anti-competitive conduct, that is, the search payments for default in the Google case, rather than any kind of product superiority. In the middle of this, in a case that Google is citing a lot, is the Rambus case, which actually took a stronger position on causation and held that even condemnation for monopolization was improper unless the government was able to show that the defendant's conduct was a but-for cause of the monopoly position. So those are the things that the judge is going to have to iron out in the next 2 months. Really, he's promised a remedy by August. My guess is that, given the state of the record as it is right now, it cannot be clearly established that Google's dominant position was caused substantially by the payments for default. And that suggests to me that Judge Maida is not going to order a divestiture. He probably will order one or more amendments to various contracts and licensing agreements. He will very likely stop the large payments for default status. One thing he's also likely to do is force Chrome to have a choice screen, just like you've got here for Android devices in the EU. But when you first boot up and make your decision to use Google Chrome as your browser, which is where search engines usually reside, you'd have a choice screen and you'd have to pick from uh, several browser, uh, one of several search engines. And then finally, there's going to be some kind of data sharing, although the data sharing problem is tough. It's a tough problem because right now we don't know what the economies of scale are in data production. Do they level off at a certain rate? Everybody knows you need a big database to have a successful search engine. Do they level off at a certain amount, like say 20% of the market? Well, if that's true, you could have room for 4 or 5 search engines that would be equally good. On the other hand, if they keep getting better and better and better as the database gets larger, then there's only going to be an equilibrium uh, of one firm. And then lurking behind all of that, something that Thibault's much better able to speak to than I am, is the product differentiation capabilities promised by AI. I mean, one of the reasons Google search is so dominant is because it has historically been very difficult to differentiate Google search. We don't have that problem in lots of other big platforms like social networking, where you can have an equilibrium with multiple platforms, social network platforms, but each of them is different from one another. They don't face the same demand curve, and as a result, you can have a multi-firm equilibrium. We may get that as a result of AI. Will create significant differentiation in search, and that could be a very, very good outcome in this case. Okay, I've gone a little bit over, but I'm done.
Thank you very much. Okay, I'm going to ask you 2 questions to get things started, and then we're going to open the floor.
Okay.
The first one is this. So you've mentioned AI. So the fact that we have now generative AI creating some sort of competitive pressure, we'll see how big that is, in search is irrelevant to qualify the practice that happened in the past, right? However, it may have some relevance in measuring the effect of the practice and even more when designing the remedies. Do you think that the fact that we now use ChatGPT and Claude and others to do some search-related activities should play a role in how Judge Mehta is going to design those remedies?
There's 2 answers to that. One is, in a perfect world where you had a perfect record, it should clearly play a role. He is dealing with a record which, quite frankly, does not have a lot in it about AI. AI was really not up there in front of everybody's face at the time this action was brought, and even when it was litigated. And if you read the original liability opinion, AI really is practically non-existent. So yeah, I mean, he's going to have serious limitations there. But just one point about this, and that is that all of our economics of natural monopoly, which is common, in utilities and things like that, they all rest on the assumption of a single demand curve. The reason we've got natural monopoly is because we've got a whole lot of people fighting under exactly the same demand curve, and as a result, they compete on price, and that's about it. And then economies of scale can mean that only one firm can survive. As soon as you have multiple demand curves, because each one is a slightly different product that appeals to a slightly different group of users or combinations of users, then you get the possibility of equilibria in which stable situations in which you could have multiple firms, each holding a significant portion. I don't think you get 15 firms, but you could certainly get 4, 5, 6 of them, in which each of them owns a significant portion of the market, but they appeal to a little bit different kind of customer than someone else's search engine. And of course, so far at least, multi-homing has been virtually universal in search engines. So, you can have 2 or more search engines, pick one for one purpose, pick a different one for another purpose, switch back and forth, and so on. So we could see a competitive equilibrium emerge.
Second question, and then it's going to be your turn. You've mentioned the fact that innovation is here and there mentioned by the agencies and court when looking at the consumer welfare standards. in the EU, I find doing some empirical work on the subject that you see not a lot of consistencies in how the Court of Justice of the EU is looking at innovation and the role that it assigns innovation in antitrust cases. It seems that for very similar practices, innovation is or is not playing a role, and it's a bit, pretty much navigating on a case-by-case basis. Looking at the US, are you under the impression that courts are consistent in how they deal with innovation, or are we still in a position where we need to make it more coherent?
I don't think our experience is a whole lot different from yours. Innovation is, first of all, innovation is the most poorly behaved of the three elements: price, output, and innovation. It's the least predictable. Judges understand it the least. It's not always so obvious how it relates to output. And so, yeah, it's harder. It's harder to get innovation worked into your competition law models, although it certainly can be done. Merger guidelines, for example, in the US since at least 2010 have always included restraints on innovation as one of the criteria for evaluating mergers. Although the interesting thing is when they talk about restraints on price or output, you get a pretty detailed discussion of the metrics, how to go about evaluating this. When you see the statement about restraints on innovation, it's usually just there all by itself and waiting for something else. We've got this very interesting episode in Microsoft in which, if you recall much about Microsoft, Netscape depended on the existence of a multi-platform chip, a chip that could read across multiple operating systems and integrate them. So basically, computers with different operating systems could talk to each other over the internet. And Intel was in the process of developing such a chip when Microsoft basically threatened Intel that if it did not halt distribution of this multi-language chip, Microsoft was going to look somewhere else for a supplier of processing chips. So it was a direct, naked restraint on innovation, and the DC Circuit had absolutely no problem condemning it, although it had a very difficult time coming up with any metrics for determining how it should be condemned. I think the fact that it was a naked restraint on innovation helped the court a lot because it really didn't have to quantify the extent of any harm to innovation, which of course was all in the future. I mean, the whole purpose of the venture was to foreclose technological opportunities that had not yet been developed, and it's not easy to put dollars and cents numbers on those.
All right, thank you very much. We have about 15 minutes for questions. Today's the day. If you can make it to Philly, by the way, you have great Philly cheesesteak. We can talk about that, and maybe it's an occasion to have another discussion with Herb. But he's here with us today, so who's first? Yelena? Yeah.